Road. My client arrived at Washington High School. I talked to two officers before he was asked to take an MET, a mobile breathalyzer test. After refusing multiple times, the principal then told Mr. Jones that he had to pass the test in order to get into the event. He refused again and was denied access to the prom. These are the basic facts of the case. However, it's not that cut and dry. There was a clear violation of his Fourth Amendment rights. The Fourth Amendment to the United States Constitution prohibits unreasonable searches and seizures and requires any warrant to be judicially sanctioned and supported by probable cause. This is part of the Bill of Rights and was adopted in response to the abuse of the writ of right of assistance, a type of general search warrant issued by the British government and the main source of tension during pre-revolutionary America. Because the Bill of Rights did not initially apply to the states and federal crime investigations were less common in the first century of the nation's history, this was a little significant case law to the Fourth Amendment before the 20th century. The amendment was held to apply to the states in Matt versus Ohio in 1961. Under the Fourth Amendment, search and seizure, including arrest, should be limited to scope according to significant information issued by the issuing court, usually by a law enforcement officer who has sworn by it. The Fourth Amendment case laws deal with three central questions: what government activities constitute search and seizure, what constitutes probable cause for these actions, and how violations of the Fourth Amendment rights should be evaluated. Early court decisions limited the amendment's scope to law enforcement officers' physical intrusion of private property, but with Cass versus the United States in 1967, the Supreme Court held that its protections such as warrant requirement extended to the privacy of most search and seizure activities. But the court has defined a series of exceptions for constant searches, motor vehicle searches, evidence in plain view, and border searches. On April 17, 2013, in Missouri versus Neely, the Supreme Court clarified that the extenuated circumstances exhibit in the search requirements required the government to provide that there was no time to obtain such warrant before the evidence seized in the warrantless search was admissible at trial. Although the search in McNeely involved the search and seizure of the defendant's blood, the rule applies to other searches such as the search of the defendant's breath and form of breathalyzer test. If the school had time to hire police officers and print the rules on the tickets, surely they had plenty of time to get the warrant. Indeed, in Skinner versus the Railroad Labor Executive Association, the Supreme Court explicitly held that the breathalyzer tests and searches are subject to the same limitations. Not only that, but there are multiple things that point towards some mistakes found in the schools and officers' parts. For example, students were improperly notified about the breathalyzer test, only if you could take it to the prom. Also, the officer's impressions about whether or not Mr. Jones was intoxicated was not recorded. Were the officers thinking that he was actually intoxicated? Why wasn't he given the option of a FST, a field sobriety test? Not only was no warrant issued, but there were no known reasons for the officers to not thought my client was intoxicated. Also, even if Mr. Jones was intoxicated, why was he released back into the general public and even allowed to drive away from the party? Also, this was a prom party, so why weren't the students who were also at the party denied access to the prom? Also, the parents of the house, surely they should have been charged with providing underage students with alcohol. And the fact that my client wasn't arrested or expelled for underage intoxication on school property, along with a number of other charges, probably because my client wasn't actually drunk. Also, the prom is extremely important from a law enforcement standpoint. In a lot of schools, youth really just sit down, shut up, and only speak when you're spoken to. The prom is the only time during the year that the students are actually allowed to act social with their fellow students with their parents' permission. While prom is voluntary, so is graduation in college. We are socially expected to go to these events and, among others, when the students are at prom, they're off the streets, preventing them from causing trouble. They are in a closed, protected location where, in theory, they won't be doing the things they would if they were out on the streets. Not only, Your Honors, was my client's rights violated, but he flat out denied access to an important event for not doing something that he may or may not give you the right answer. Your Honors, I'm not only asking you to rectify this wrongdoing, but I'm asking you to uphold the constitutional ideas and precedent set by previous cases.
Okay, I just have to say, you definitely May it please the court, my name is Griffin Petty, and I represent the Appealee Washington High School, who argues that the policy did not violate Jack's Fourth Amendment rights. Today we're here to discuss a Fourth Amendment that was supposedly violated, and we're here to discuss whether privacy is more important than safety. The reason we spend millions of dollars on safety for these events is because safety becomes our top priority in these cases. We rely on the future of our youth, and the youth becomes our future, so we have to protect the youth in these type of cases. And why would the prosecutor refuse to take a test if he had nothing to hide? The school ground is a place where teachers and administrators must protect their students. Why would Mr. Jones be the only one to refuse a breathalyzer test at this event? Mr. Jones says that this is an invasion of privacy, but what part of this is an invasion of privacy? These are digits given to us by a machine and give no personal access to your information. We look at these because intoxication can lead to dangerous things. It can lead to anger, rage, and about 97,000 students are raped in this country, and 18 to 24% of them are women. That's all, Your Honor.
Attorney for the
Your Honors, my client denied the breathalyzer test because he has a respiratory infection. When you have a when you are taking a breathalyzer test, you have to breathe forcefully into the tube. Having a respiratory infection means he had trouble breathing as it is. And so how can he possibly give the breathalyzer test to the full extent to give a probable digit reading of alcohol level if he can hardly breathe himself? Also, he says that this is not a manner of evasion of privacy. Actually, in multiple case studies, including one written in 1983, it's found that breathalyzer tests can actually turn up DNA information. And in the case of Skinner versus the Railway Labor Executives in 1989, they actually found that random drug tests was actually illegal depending on the situation, on breathalyzer tests given by police. So it's been held by superior courts such as the United States Supreme Court that at certain points breathalyzer tests are actually a violation of one's Fourth Amendment rights. And on top of that, he was just blatantly denied basic rights while other students from the same party were allowed into the home. That's all you know.
will announce his decision shortly.
Do you not want to ask the attorney's questions first?
Justices, do you all have any questions?
I have a question. Okay, you said your client has a respiratory infection, but he was notified that it was required to take a breathalyzer test. Why didn't he have a solution beforehand if he wanted to get in the prom? Because he was notified that it was required.
As I stated before in my opening statement, the students weren't properly notified of the breathalyzer test. They were only notified via the prom ticket, and some of the students received prom tickets through 9/11. So the students weren't actually properly notified. And so he couldn't properly assume that he had a breathalyzer test. Even if he was properly notified of the breathalyzer test, he should have been able to receive a Phillips Friday test as the
Any other questions? No questions, ma'am. I have questions. Give me 1 second.
this back and forth. It's great, but you would be so out of order to be talking to one another as opposed to the justices, so you can boast that.
I have a question for the Paley. Do school children have the right to Fourth Amendment protection against unreasonable searches and seizures?
Your Honor, what I have in my hand is a school document from a Henry County school. It states, may I come to the post?
Handbook saying that they give up their rights to search and seizures, and they have to be susceptible of their punishment.
But wait, this wasn't at school. This happened
They're on
at.
school grounds.
This wasn't at school grounds. Did it say this? Their problems at their school? Let me read it. This says he was in possession of alcohol. That's not what this says though. It says possession not under the influence.
Ken, what's the problem now with school ground?
The problem is how that school grounds is held at any other location, but in reference to the rule that the fellow attorney has stated, while not only was it not on school grounds, as Chief Justice has already said, this was not a case of possession of alcohol. This was a case of assumed intoxication of alcohol.
Thank you very much for that, because this is talking about, is it possession? Nowhere under here does it say if they believe that the student is under the influence or anything like that, so.
Nicholas, if it wasn't on school grounds and they didn't bring the code of conduct out of the handbook, how was that your problem?
The student was at a party where alcohol was served and did not let authorities know that he was at a party and did not tell the alcoholic beverages at the party. So therefore, he's aiding and abetting underage drinking.
But did he get arrested for that?
No, Your Honor.
So how was that, you're his principal, how was that your problem?
The student denied a breathalyzer test and was forced to take one, or was forced to take one, so he did not get a breathalyzer test to prove that he was intoxicated.
Praise